Ashley Ossentowski versus Brandon Ossentowski, 22-7-354 DM. This is plaintiff's motions. Plaintiff is present, represented by attorney Amanda Rogenbuck. Mr. Ossentowski is in pro se. Will both parties please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am. Ms. Rogenbuck, you may proceed.
I would call Brandon Ossentowski, please.
Mr. Ossentowski, please step up.
I apologize for coughing, Judge. It's not contagious. We haven't had a good enough frost to kill everything that makes me cough.
Oh, yeah, I'm ready to swear.
Oh, that's right. I just swear, it's Friday.
Yep.
Thinking about the big storm. Ms. Rogenbuck, you may proceed.
Thank you. Sir, can you state your record or your name for the record, please?
Brandon Ossentowski.
And at one point, Mr. Ossentowski, were you married to the plaintiff Ashley Ossentowski?
Yes.
And do you recall last summer signing a consent judgment of divorce that was entered by this court?
Yes.
And do you recall reviewing that judgment with your team of your legal team?
Yes.
And you agreed to the terms of that judgment of divorce, is that correct?
Yes.
Okay. Mr. Ossentowski, part of the judgment of divorce requires that you assume the responsibility for a loan at Team One Credit Union. At that time, the loan was $5,826.24. Do you remember agreeing to that?
Yes.
Have you kept that loan current throughout the process since the entry of the judgment of divorce?
On this one thing.
Okay, Mr. Ossentowski, if I may approach, Your Honor?
Yes.
I'm going to ask you if you can review this document. Do you know what that document is? And does that look like a screenshot of the loan balance at Team One Credit Union that you were required to assume for the consent judgment of divorce?
There's multiple loans at that bank, so I don't know which one this is. This is 4,300.
Okay, thank you, Mr. Ossentowski. Mr. Ossentowski, are you aware that according to Team One Credit Union, my client was in default because you failed to make your payments on the loan in a timely fashion? And were you aware that the account has been locked out at Team One Credit Union? Okay, are you aware that pursuant to the judgment of divorce, you were required to keep that loan current at all times? Okay, and you're aware that the judgment of divorce says that if you don't keep that loan current, that Mrs. Ossentowski can come back in and she can get all of her fees and costs, including any penalties the court wants to assess you for being in default on that loan. Do you understand that? Okay. Mr. Ossentowski, are you aware in your judgment of divorce there was a requirement that you turn in your tax papers so the taxes from 2022 could be filed before the extension ran out in October?
Yes.
Did you do that, Mr. Ossentowski?
I was unable to, but my attorney was supposed to be handling it.
Mr. Ossentowski, when did you get out of jail last time?
This is true.
Okay,
It's September.
so in October, were you incarcerated?
No, ma'am.
The CPA is in Baddocks, correct?
Yes.
And you live in Baddocks, correct? Were you incarcerated in November?
No.
CPA is still in Baddocks?
Yes.
You're still in Baddocks?
Yep.
Were you incarcerated the month of December?
No.
CPA is still in Baddocks?
Yep.
You're still in Baddocks?
Yep.
And we are at January 12th. You're clearly not incarcerated in the month of January, correct?
Nope.
So between the time you got out in September and the time you got out in January, the judgment just didn't apply to you?
Again, I had an agreement with my attorney, had all my tax information, scanned it over to the CPA. Talked to him yesterday, and I guess that never got done. It's done now, but I was under the impression it was done. I didn't know it wasn't done until I got notice of this hearing.
Mr. Ossentowski, did the judgment of divorce bind you or your attorney? Meaning, do you have to turn in your documents according to the judgment, or does your attorney?
Oh, me?
Okay. Mr. Ossentowski, are you aware that the judgment of divorce requires you to pay child care through the front of the court?
Yep.
And at some point last year, did you take a check into the front of the court for $1,885.60? And that check did not have sufficient funds at the time you turned it in, is that correct?
That is it.
That is incorrect?
Yes.
So if the front of the court testifies you turned in a check with insufficient funds, she's lying?
Absolutely.
Okay.
The date was wrong.
Mr. Ossentowski, that wasn't the question I asked you. Please stick to the question. Mr. Ossentowski, at some time, you and Ms. Ossentowski came back in and there was an addendum to the judgment requiring both of you to get psychologicals with Douglas Bay. You remember that?
Yes.
And you have completed that with Mr. Bay?
Yes.
And you are aware that Mr. Bay will not complete both of them?
So told.
Okay? Did you follow up with Mr. Bay? Did he tell you anything different?
That's not my business. What he does with the professional is,
But the answer is you didn't follow up with him?
no.
Okay. Mr. Ostenowski, do you have any arrears on your child support?
I got a letter, yeah, he owes me.
How much money do you owe, Mr. Ostenowski?
I think it's 4,500.
$4,936 sound correct as of January 9th?
The letter I got says 4,500.
Okay, but if the friend of the court testifies that as of January 9th, it was $4,936.00, would you dispute that as she's telling a lie?
No, I'd like to see the information. Right?
Okay. Mr. Ostenowski, from the judgment of divorce, we know that you own a sleep number bed, is that correct?
Yes.
If I may approach, Judge?
You may.
This is plaintiff's proposed exhibit 7. I'm going to ask you to review that, Mr. Ostenowski. Tell me what the billing name and address is on that file. Middle of the page to the right.
I see it, Brandon Rosentowski.
And is that you?
Yep.
And is that your address?
Yes.
For the record, what's the address listed?
I can move, Mr.
And is that in FedEx?
Yep.
Is that your home?
Yep.
What's the date on that invoice?
For 21-23.
So September 21st of 2023.
Yep.
Did you place an order to sleep number on or about September 21st of 2023?
Yeah, for a new pillow,
Okay, and how much was the total of that pillow, sir?
$118.
Your Honor, I would ask the court to receive people's or plaintiff's proposed exhibit 7.
Objection. Gender, item 7 is in.
Thank you, Judge. Mr. Ostenowski, what's the going rate for fresh crab legs?
I'm not sure.
Okay.
Depends on where you buy it.
Your Honor, if I may approach,
Sure.
I'm showing in plaintiff's proposed exhibit 8. Mr. Ostenowski, is that a screenshot of your phone? It indicates your name and your picture. That's a different Brandon Ostenowski from FedEx.
My phone.
Okay,
Screenshot of my phone.
okay, Mr. Ostenowski. Judge, if I may approach again.
Sure.
Mr. Ostenowski, I'm going to show you plaintiff's proposed exhibit 9. You recognize this gift card and the handwriting for $100 on the gift card?
Yeah.
And what does that gift card represent?
That was a gift card I gave to my ex-mother, father-in-law for taking my daughter to her appointments.
And that was in the amount of $100?
Yes.
So you don't dispute that you bought that? You spent $100 on it?
Yes.
I would ask that the court accept plaintiff's proposed exhibit 9.
Any objections? 9 is in.
Thank you, Judge. And if I may approach one last time.
You may.
Mr. Ostenowski, I'm going to ask you if you recognize this photo.
Yeah.
What does that picture represent, Mr. Ostenowski?
The grill that my mom replaced with it.
So that was a gift to you.
Yes.
Approximately how much was that gift?
First one was.
Okay. How much was this one, if you can approximate? Is it similar to the one you received before?
It's similar, but the first one was a Father's Day gift, and this one was the mom that got home to my mom.
Okay, let's focus on this picture.
Okay.
This grill, similar to the grill you had prior.
Yeah.
So it's a fair assessment that the price would be similar, $350 to $400.
Yeah.
Okay, and that's in your possession now, is that correct?
Yes.
Okay, and you don't deny that this is a screenshot of your grill,
No, it's
and it's a screenshot of your phone?
not on my phone.
That's not your phone, Brandon Ostenowski's phone, but it is your grill.
That is a picture of my grill, yes.
And the picture of your grill lists the name Brandon Ostenowski. Are you telling me there's a different Brandon Ostenowski that has a picture of your grill?
I'm telling you that I'm aware of Snapchat, and you can change anybody's name to whatever you want.
Listen to the question.
That is not mine.
That's not your Snapchat.
No,
That's a different Brandon Ostenowski.
it's not my Snapchat.
Is it a different Brandon Ostenowski?
I don't know.
But it's your grill
That is my grill, yes.
in a different Brandon Ostenowski Snapchat.
I'm not aware of any of the Brandon Ostenowski's, but it's not my platform.
I would ask the court to receive plaintiff's proposed exhibit 10.
Any objection?
No.
10's in.
Mr. Osinowski, are you aware that you're required to keep your child support current?
Yes,
Are you aware that you're required to keep your daycare support current?
yes,
Are you aware you're required to keep the loan current?
yes,
Are you aware that your defaults have caused harm to Ms. Osinowski?
I'm unaware.
Okay. Do you believe that nothing happens when somebody defaults on a loan?
Again, I missed one payment.
Okay, Mr. Osinowski, do you understand not making a payment is a default on a loan?
I understand.
Okay, so again, the question is, do you believe nothing happens when you default on a loan?
I did believe something happened, but not right away. My name was on the loan as well, and there's something,
So, Mr. Osinowski, if the bank has sent letters saying that they're going to take my client's car because it was collateral on your loan, would the bank be lying that nothing happens?
I don't know if it's collateral or loan.
Okay, were you present when the loan was taken out that you assumed, Mr. Osinowski?
I was present briefly to sign.
Okay, and you're an adult, right?
Yes.
You can read, write, and understand the English language. Okay. You understand that you signed a judgment of divorce that requires you to do all of these things in a timely manner. You understand that?
Yep.
You understand that if you take an action or fail to take an action and it causes harm to my client, you agreed per the terms of the judgment of divorce that she could come back and get all of her attorney fees and costs for having to enforce the judgment of divorce. Do you understand that?
Sure.
Okay. Do you understand, Mr. Osinowski, that the court now has evidence that you've had money to buy Red Lobster gift cards, you've got lavish gifts, you had money to buy a pillow for $125, but you didn't have money to make your child support payments. You didn't have money to make your loan payments. You understand that?
My child's birthday was a date.
Do you have an arrearage, Mr. Osinowski?
I'm aware of.
Mr. Osinowski, do you understand an arrearage means that your child support
Oh, I'm
is
sorry,
not current?
I'm sorry, I'm not my date here.
Okay.
I'm sorry. The date.
So you understand that your child support's not current?
Yeah.
You understand you didn't comply with the terms of the judgment with regards to that?
Yeah, this is all new to me, I didn't know the child
Okay.
support word.
Mr. Osinowski, yes or no? Did you turn in your paperwork to your CPA in a timely fashion like you were required by the judgment? Yes or no?
I did not, no.
Okay. Did you make all your payments on time on the Team One credit union loan? Yes or no?
I missed one of them.
Did you make all of your child support payments so there's no arrearage on time? Yes or no?
No.
Did you pay everything you were required to pay on time in this case per the judgment, Mr. Osinowski? Okay. Judge, I have nothing further at this time, but I reserve the right to recall the witness.
Do you have any explanation, sir? You are called to the stand, you can give an explanation, you're under oath.
Yeah, I don't think everybody realizes what I had to endure when I got to jail. I would like to go over the divorce decree on a lot of items that were taken on the home. I had to refurnish my home entire
I'm
home.
gonna object, Judge. We're not here to talk about the divorce
It's an
decree
explanation.
at all. It has nothing to do with whether or not Mr. Osinowski complied with the divorce decree.
We're talking about an explanation of compliance with the divorce judgment.
Well, that's part of the reason I didn't comply because I had nothing when I got home. We supplied my house with everything from oxygen to spoons and forks, a pillow. I mean, I've done my best to, keep everything up to date. The loan is paid off now. I take the loan in full. I will pay the child support in full today. I'm very confused on a lot of things. I feel like I was misrepresented when I attorney and there's a lawsuit.
I'm gonna object again, Your Honor. This isn't the time or place. You have to sue his attorney.
Just say. But you just stated a moment ago that you're going to pay the child support up in full today.
Yeah, I didn't realize.
We're talking nearly $5,000 according to testimony. You're able to do that. Okay. The childcare expense is the $18.55 and 60 cents. Has that been paid?
Yeah.
So there's no issue regarding outstanding childcare expenses?
No.
Okay. And you say that the loan is paid off as well?
Yes.
Or will be paid off?
It's paid off.
It is paid.
I received.
Any questions in light of the courts?
Yes, Judge.
Go ahead.
Mr. Osinowski, when did you pay the loan in full?
Yesterday, as you know,
And when did you receive the notice that we were bringing you to court?
actually, I got served at my daughter's daycare, or not daycare, but her therapy session. I which would have been 2 weeks ago.
December 21st, does that sound correct? Based
Yes.
on the proof of service, and you were served personally in Saginaw, correct?
Yes, but I also want to state that
Nope. And so as of December 21st, you knew that you were coming back to court. You were served with papers telling you were bringing back to court for all of these things you ignored in the judgment of divorce, correct?
I didn't ignore them.
Mr. Ossenheim, let me rephrase. You didn't do the things that we've talked about in a timely fashion, yes or no?
I was aware I had
Yes or
until
no, Mr.
20th
Ossenheim?
of January.
Your Honor, I'm going to ask you to direct the witness to answer.
Well, it's actually asked you to answer. You stated it did not.
Mr. Ossenheim, you have the funds with you to pay the child support in full
Yes,
today,
yes.
before you leave this building.
I was going to get a check with our truck, yes.
Is that a personal check or is that a certified cashier's check?
Whatever you recommend.
Okay, so
My checks are good.
you'd be comfortable paying in the future with cashier's checks and money orders so that there's no issue with your checks bouncing in the future?
My checks never bounce.
Mr. Ossenheim, the question is, would you be comfortable paying in the future? Yes or no?
I would be actually more comfortable paying daycare directly.
Then that motion, Mr. Ossenheim.
I don't know, this is very confusing.
Judge, I have nothing further at this time for him. I would request to call the front of the court, and then we have some additional questions based on the testimony.
Call your next witness.
Yes, I'll answer it, please.
Please raise your right hand.
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help God. I do.
Good morning, ma'am. Could you state your name for the record, please?
SCHULTZ.
And what is your position?
And the friend of the court, Legal Services.
Thank you. Judge, if I may approach, please.
You may.
I'm showing you what's marked as plaintiff's proposed exhibit 4. I'll give you a moment to review that. I think you're probably familiar with that. Does that letter reflect a conversation that you had or a notice that Mrs. Ossenheim received about a check that she got through the front of the court, but written by Mr. Ossenheim?
This letter came from another staff member that handles medical and other reimbursements for our office.
Correct.
But Ms. Ossenheim did email me after this payment to express concern regarding that.
And is it correct that the position of the front of the court is absent a court order, they have to continue to accept personal checks from Mr. Ossenheim?
For this type of reimbursement, because it is not payable through us, it goes directly to Ms. Ossenheim. Our office policy for support purposes is that we cannot pay personal checks.
Okay.
Because by the time we have received notice of the check being non-sufficient funds, that money has already been released to the state.
Okay. And it's a fair assessment that in your conversations, either via phone or by email with Ms. Ossenheim, she expressed a concern that she took a check in, there wasn't sufficient funds, so she couldn't cash it.
That is correct.
And it's your understanding, just like her, your office doesn't take personal checks for a reason. Right. And your office is familiar with accepting cashier's checks and money orders, is that correct?
That is correct.
And it wouldn't create a hardship for your office to accept a cashier's check or money order versus a personal check, is that correct?
Absolutely.
I would request that the court receive proposed exhibit 4.
Any objection?
No.
Or is it?
Ms. Ossenheim, I'm sorry, Ms. Schultz, let's talk about the arrearages. Can you tell me today, the last update I had was January 9th. What is Mr. Ossenheim's arrearages on his child support today?
May I look at my,
Yes, ma'am.
within the Michigan Child Support Enforcement System, the arrearage as of December 31st is $4,303. The balance due for child support as of today is $4,936.
So to be clear, today is $4,936. Correct. Okay,
That includes the January 24 terms.
thank you. I have no further questions of this witness, Judge.
Mr. Ossenheim, do you have any questions of Ms. Schultz?
I do,
Please stand to you for any questions.
So the check, did you personally see the check?
I personally gave that particular check to Ms. Ossenheim.
And the date on the check,
I didn't look at the date, it was in an envelope, I had her sign a receipt confirming that she received that.
So you personally don't know if the check was insufficient funds or the date was.
Objection, has to be answered.
The only information that I have is an email that was received from Ms. Asenpaski after she had cashed that.
So nothing from the bank or.
We wouldn't receive that, the check wasn't payable to our office.
Okay. That's okay.
Any other questions?
Nothing, Judge, thank you.
You may say. Next witness.
I would call back on Asentasky, please.
Stay right there. She's sworn. You may proceed.
Thank you, Judge. Judge, if I may approach the witness. I'm going to ask if you recognize this document. Yes. Could you tell me what that document reflects?
This is showing the loan payment that he was not even current. It said the next payment date was December 5th. Also, yeah, this is the joint.
And so the court is clear, this is the loan Mr. Asentasky agreed in the consent judgment of divorce to assume, is that correct?
Yes.
You relied on the assumption that he was going to keep this current per the terms of the judgment of divorce,
Correct.
and him not keeping it current has caused you harm?
Correct.
Okay. If I may approach.
You may.
I'll ask the court to receive plaintiff's exhibit 1.
Objection to one?
No.
It's it.
Thank you, Judge. Ms. Asentasky, let's talk about what's happened when Mr. Asentasky became delinquent on the loan that he agreed to assume. Have you had any issues at Team 1 since that occurred?
Yes.
And can you describe those, please?
They told me that they would repossess my car if it wasn't paid, that there were multiple late payments, that multiple different collection calls saying that it was over 30 days late.
Okay, Judge, if I may approach the witness.
You may.
I'm going to ask you to look at what's marked as plaintiff's proposed exhibit 2. Can you tell me what that letter reflects?
This is saying that if the amount past due was not paid, that they would repossess the car.
And who's that letter from?
Team 1.
And it was addressed to you?
Yes.
Is your car cross collateral on the loan that Mr. Asentasky assumed in the judgment of divorce?
Yes.
Have you been locked out of the account?
Yes.
So you can't go in and do anything until Mr. Asentasky makes that loan current, is that correct?
Correct.
Okay. Judge, if I may approach, I would ask the court to receive plaintiff's proposed exhibit 2.
Any objection to?
May I review
Yes.
You may. Absolutely. I actually have a copy for you. Just make a note, I'm handing Mr. Asentasky a copy.
It shall reflect the same. Your position on the proposed exhibit, or any objection to its admission?
No.
That's your copy, Mr. Asentasky. Thank you, Judge.
Minus 2.
Ms. Asentasky, there have been a couple of hearings post-judgment that I did not represent you on. You went in pro per, correct?
Correct.
And at one of those hearings, I believe it was the first one post-judgment, there was an addendum made to the judgment of divorce. Do you remember that addendum?
Yes.
And it was part of that addendum that each of you received your psychological from a gentleman named Douglas Bay.
Correct.
When you called to connect with Mr. Bay, did he advise you he would not be able to perform your psychological?
Correct.
And did he advise you why?
He said it was a, got the word, that he was representing, or he saw him, so it would be.
Did he essentially tell you that it was
He
a
could not
conflict
do
of
it, yes,
interest?
conflict of interest.
Okay.
Is what I wanted.
And you are more than willing to take a psychological, correct?
Yes.
And you actually have an outside vendor that you had started to set up with prior to this hearing, is that correct?
Yes.
And that's where you would plan on going back?
Yes.
And can you disclose the name of it, if you remember right now? I know you've got a couple other things happening.
I don't remember the name, but it was that.
Okay.
It was the one that the court had recommended.
Ms. Asentasky, I want to be clear. You signed the same judgment of divorce as Mr. Asentasky, correct? You relied on the terms of that judgment of divorce, is that correct?
Correct.
You thought all of this was going to be behind you.
Correct.
To date, you are owed almost $5,000 in arrears and child support.
Correct.
I don't have any evidence other than Mr. Asentasky's word that he paid the loan off, but we do have evidence that the loan is delinquent, correct?
Correct.
And Mr. Asentasky has violated multiple provisions in the judgment, is that correct?
Correct.
Are you asking the court to hold him in contempt?
Yes,
Are you asking the court to order the following? That the loan be paid in full immediately with documentation provided to prove that's done.
correct,
That his child support be paid in full immediately.
correct,
That he in the future either pay by cashier's check or money order for any amounts due to you, either to you or through the front of the court, whichever the court order requires.
correct,
Are you asking that Mr. Osentoski and you file your taxes separately for 2022?
Correct.
Now, 23 forward, you're already separate, correct? You guys had an extension until October of last year,
correct,
and you have maintained constant contact with the CPA, is that correct?
correct,
And that contact with the CPA has indicated since the entry of the judgment of divorce that the CPA has received zero documentation from Mr. Osentoski,
correct,
and as such couldn't file your joint tax return.
correct.
Historically, have you and Mr. Osentoski owed taxes together?
Like paid in,
Yes.
correct,
And is that historically because he's self-employed and he waits till the end of the year?
correct,
Is there potential that you will receive penalties or fines or interest due to Mr. Osentoski not filing his documents timely?
correct,
And you are asking the court to change it so that you can file separately for 2022, is that correct?
yes,
Now, Adeline's lived with you since the separation?
Correct.
Correct? You've been her sole care provider?
Correct.
Are you asking the court to allow you to claim her for 2022, all tax purposes as well?
Correct.
Okay. Is there anything else that you think the court needs to be made aware of?
No.
Okay. Judge, you have nothing further at this time. If Mr. Osentoski has questions, I may have some follow-ups.
Any questions of Ms. Osentoski, sir?
Did the.
No, you, at this point, you can say, because
Okay.
this is right next to you.
Did the CPA advise you that we still needed to turn in our the house property taxes before they could do our
Objection.
taxes?
Yes, her to testify to hearsay what the CPA advised her.
And there was rank hearsay brought by you as well.
I understand that.
Go ahead.
'Cause when I went there, they stated that we needed to pay the property taxes before they would do any taxes anyways. So I was unaware that.
I'm gonna object.
You have a question, sir. You have to ask a question. I'm assuming that's the objection.
Yes, Judge, thank you.
No, Your Honor.
Okay, thank you. For the proofs.
I do now, Judge. I would like to approach the witness. Plaintiff's proposed exhibit 3. Ms. Osentoski, do you recognize that email chain?
yes.
And can you tell me what that email chain is?
This is, back and forth with the CPA regarding documentation.
And during your emails back and forth with the CPA, do they indicate that they've seen Mr. Osentoski or communicated with him?
They said that they have not gotten anything from him.
And do they indicate that you need to provide further documentation?
They have not said anything,
And is it a true statement that you provided everything you believed you were to provide?
correct,
And it's your understanding that they're waiting on Mr. Osentoski?
correct. And I did say, please let me know if there's any further information I need to provide.
And what date was that?
August 14th.
Okay. Mr. Osentoski, would you like to see this?
No.
Okay, Judge, I would ask that the court receive plaintiff's proposed exhibit 3.
Any objection?
No.
It's admitted.
Thank you, Judge.
You're welcome.
Judge, I have nothing further at this time except for closing.
Thank you. Sir, do you wish to present any proofs?
I have the receipt. I thought that was a receipt.
You have what?
I thought I had the receipt from the T1 loan, but I brought it.
Okay.
No, I don't have anything.
Closing argument.
Thank you, Judge. Judge, we would simply ask that the court hold Mr. Osentoski in contempt. It's our intention that he stay out working so he can support his daughter. His own testimony today indicates that he's disregarded the judgment or ignored it or not understood it. But in any event, Mr. Osentoski's testified that he can read, write, and understand the English language. He signed this. He was represented by a team of lawyers in the process. And Mr. Osentoski agreed to the terms. I'm sure the court remembers how lengthy the pro-con hearing was to go through all of the elements of this judgment, so everyone was on the same page. Yet today he comes in and he says, I paid off the Team One credit union loan. Oh, didn't bring the receipt though. I can pay all of my child support. I've got to go get my personal checkbook. He doesn't dispute the fact that he's delinquent, that he's ignored the judgment, that he has an excuse, and that seems to be the case every time we come to court. Mr. Ossentaski has an excuse. We would like the court to order that the team loan be paid in full immediately with documentation provided within 3 days, that he be held in contempt, that his child support be brought current by his own admission. He has the ability to do that today. That the parties file separately for all state, federal, and local taxes for 2022, that my client be able to claim the minor child as the person who supported her through that year, that my client seek her psychological examination forthwith with an alternate vendor, that any further payments for the friend of the court or that have to be reimbursements to my client be by cashier's check or money order, and that my client be awarded all attorney fees and costs for having to come to court on this.
What are you requesting regarding attorney fees?
Your Honor, I can prepare a bill for you once we're done. We have no idea how long we're going to be today. I think we'll be upwards of about 1,500.
Sir, your closing argument, please.
Yes, Your Honor, as you know, I got out of jail late September. I had a lot of things to deal with when I did get out of jail. I had to refurnish my house. I was busy with counseling appointments, trying to figure out what was going on with my daughter. I'm not making any excuses, things did get overlooked. I misplaced the judgment of divorce at one point in time, and I don't want to make excuses. I failed to pay on the loan and this one payment. I was aware of the judgment of divorce and said I had until January 20th to pay it in full. So I guess I don't understand. I didn't know this one payment. I didn't know the penalties that Ashley suffered. I have an account there as well. I didn't get locked out of anything. So again, I don't know why they locked her out, got me out. I missed December's payment. And I thought I had until the 20th of January to get it all out. You are aware, I owe Ashley a very large lump sum of money. I think that's by the 20th, $30,000, $35,000. So, the stress and everything going on with my life, my daughter, trying to replace things that were taken out of the home that were not agreed on in the.
Objection. Not relevant.
It's been very hard for me to get back. So it's very hard to get back on my feet. And like I said, with work, I am self-employed, so trying to bounce back and forth with homeowners and counselors and court, and it's difficult. I've only been out of jail for 4 months. Just trying to get by. I'll do my best to stay up to date on everything from here on out. I feel like I was misrepresented. That's
Objection.
No.
Not relevant.
All right. Based upon the testimony presented, the evidence presented, the court finds the defendant in contempt of court. He's failed to comply with the judgment of divorce that was previously entered in this case. As a result, the court will order in part first that the loan payment or the loan amount that the defendant testified to under oath that was paid in full is to provide a receipt to counsel that indeed that was paid, or if not, have it paid within the next 3 days because the defendant testified that the ability. But regardless, the documents must be provided within 3 days. The court will also order that the delinquent support, as based upon the testimony made by the defendant, be paid in full no later than 3 days from today. Regarding any payments to the plaintiff relative to child care expenses, those payments must be done in either a cashier's check or a money order. The amendment of the judgment of divorce will be amended in part to allow the plaintiff to file taxes separately for the 2022 tax year. And penalties will be the responsibility of the defendant. Or will also amend the judgment of divorce to allow the plaintiff to claim minor child tax purposes for 2022 tax year. Regarding attorney fees, that is reserved at this point. I have a note here about alternate vendor. I'm not sure why I wrote that.
Oh, the psychological insight.
Oh, yes, okay. Yes, the psychological can be done by another individual based upon Mr. Bay's statement that he is unable to, I'm not sure why he's unable to do so, but I don't see the conflict, but that's not me.
I believe the vendor that was suggested was Saginaw Psychological Services.
Yes, Judge.
All right, all of it. Also, finally, based upon all of that, the court is going to order a $100 fine to the defendant for failing to comply with judgment of divorce. $100 fine will be due to the friend of the court no later than January 31. Do you have any questions, sir?
The only question I have is, why did it take her so long, Ashley so long to do her psychological, or schedule her psychological evaluation? It was ordered back in July.
I can't answer that, and that's not before the court, but you can address that in a motion if you wish. Okay. Thank you. Proceed to Ms. Rosenbuck, prepare the order.
I will. I'll have it to your office this afternoon, Judge.
Thank you. Awesome.